Good morning, good afternoon, good evening around the world. My name is Doug Brunke. I'm the founder and CEO of Global Chamber. Global Chamber is all about making key strategic connections for people who are growing their business. It's hard to grow a business. It's not simple, but we try to make it as simple as possible. For each member, we ask a lot of questions about what challenges they're having and who they'd like to meet. It's a continual process. And one of the cool things that's going on right now is we're actually collecting that information and using that information. We're beginning to understand how to connect that to artificial intelligence so it can proactively give us information and manage it. We're almost there, not quite, but we're working on it. Now, a key aspect of all of that is not only understanding members and who they want to meet, but key resources that are going to be able and key ideas that are going to be able to help members be successful. It's complicated and you can't possibly know everything. So definitely stay connected to Global Chamber. And one of the people you should also have on your Rolodex is Jeff Darr. Jeff Darr is not only a renowned global attorney who works in over 35 countries, but he also is an expert on international arbitration. He'll tell you a little bit about, I'm sure, the California International Arbitration Conference that's coming up in March. It's something that he's a co-founder of and is a strong supporter of, as is Global Chamber. If you certainly need legal support along the way, and sometimes arbitration is a solution that can work very effectively, particularly across borders. So what we thought we'd do, since Jeff is the top expert around the world on this topic, why not have him share more about international arbitration and how you can use it for your business. In addition to Jeff's day job as a leader of the Jeff and Darr, or Darr and Newman, I'm sorry, the law firm. He is so well connected in Southern California and around the world. He knows everybody. And because of that, he and I talked several years ago about having him become the Global Chamber Los Angeles Advisory Board Chair, which he very kindly took on. And he's transformed that chapter into really almost nothing to really something. And so Jeff is something, and he's been very successful not only with Global Chamber, but with his own practice around the world supporting his clients. Jeff, thank you for all that you do. We look forward to learning more about international arbitration today. Did I get anything wrong or did I leave anything out?
You did great. Thank you, Doug. And if everyone's ready, I have a PowerPoint I will share my screen with, which will help, I think, with the presentation. So let me get that set up for everyone, and I will hopefully make this interesting. We'll have time at the end for questions, I hope. So give me one moment here. Let me start my slideshow. And whoops. It's the challenge of a PowerPoint and then starting it in the Zoom. So give me 1 second here. Everyone should now see my screen. Very good. So why arbitrate international disputes, which is really what I'm going to primarily talk about today. So first, just a little bit about myself. So I've been doing international disputes, both arbitration and court around the world for over 25 years. I also frequently act as an outside general counsel for clients. So I end up doing a lot of employment law that I usually don't talk about. And then, as Doug mentioned, I have close working relationships with lawyers in many, many countries. So that allows me to, work with people who I know well. When I say know well, meaning I, have socialized with them, I know their families, that type of close relationship. I also, starting the last 2 years, now serve as a arbitrator in both domestic and international arbitration. So I do primarily as an advocate, but now I'm arbitrating cases with the perspective of both sides. So it gives me a one-up, I think, over a lot of different people. So today we're going to basically cover role of international arbitration. I'm going to sort of focus a little bit in California because I'm in California. Why interest should be there for favoring arbitration for businesses, and just a quick preview of California International Arbitration Week, which is coming up March 10 to March 13, which Doug mentioned, and Global Chamber has been a sponsor of since the first year. This is the 4th annual California International Arbitration Week. So first of all, the role of international arbitration in California, just a couple of things. So basically, what is international arbitration? And so on the screen, you'll see a little reference to what makes California somewhat unique. But basically, international arbitration is a voluntary agreement between people in 2 or more countries. Has to be a commercial transaction. So any type of international business. And by voluntary, I mean it's part of an agreement between the parties. Typically, it's in whatever contract they may have, whether it's sale of goods, licensing of intellectual property, could be anything that's cross-border. There's an agreement to arbitrate any disputes versus being silent and having it go to court. What that means is that, and you'll see in a few moments, instead of going to courts, parties have agreed privately to have their dispute resolved if they ever have one. And the reason why this is so important is, and you'll see this shortly, at the end of the day, if you want people to perform as what the contract provides, it's human nature that if people think they don't have to perform, for example, don't pay money because it may be hard to hold them accountable, maybe you'll have somebody not perform and somebody will be disappointed in their international contract. If, on the other hand, everyone believes they would be held accountable, it makes it a lot harder for someone not to perform. And that's what really is fundamentally what we're going to be talking about today. So what makes California a little interesting is California was the first state in the country to adopt its own International Arbitration Act. Most California lawyers are probably clueless that such an act even exists, even though it's right there with all the other arbitration laws, even though it's separate. And what makes it very unique and different is it's based on the UNCITRAL, which is the United Nations model law. And it's very international. It's completely different than anything that would be domestic. And as you're going to see, if you want to do transactions with people in other countries, you want to do it in a way that's similar to what they experience. And so international arbitration, frankly, is very unlike other U.S. litigation because it's really arbitration and it's international. So it follows different rules, different procedures, and people in other countries will think what we do here is exactly what they think they do in Europe, Asia, Africa, Latin America. So basically, as I mentioned, and it's codified in California, it's almost anything that's cross-border, that's commercial, that has an agreement to arbitrate will be subject to international arbitration. I don't want to get too much focus on the international legal parts as much as the common sense business parts. So if you're in California, California Act may also apply, but frankly, it's not really completely necessary because U.S. courts will enforce international arbitration agreements. And around the world, it's going to be the law of the country that will be important. So some of the little more weedy things. So if you're going to be putting in your agreement, and I get often brought in just at this part of international transaction, how to make it work. What language do you pick? What legal systems do you consider by where the arbitration may be held? What I mean by that is if you have a party's contract and there's an agreement to arbitrate, you want to have the hearing a place that's accessible. You want to have a hearing that will allow people to be not only convenient, but also maybe allow people while there's a dispute to have an ability to try to resolve it by settlement. You also want to have a place where the courts will enforce the agreement and are arbitration friendly, which happens to be in the United States, but not everywhere in the world. And that's also the place you would first go to after there's an arbitration to try to challenge the award. So a lot of little strategy things. I'm not going to talk about as much about those other than give everyone a little sense of why this is important to your business, why you should know enough about it to spot issues as a business person, and basically why you should probably, in most agreements, consider having an arbitration agreement. So first of all, international arbitration is now very well accepted around the world. It's a conventional method of international resolution, has been for well more than 30 years now. And every year, there's more attention, more awareness, and more international arbitration agreements, and there's more disputes being resolved by arbitration versus courts. And the basic reasons, and we'll go through these in a little more simple to understand detail. Obviously, we've had an increase in our global world economy. You'll see that the enforcement of arbitration awards is far more predictable than enforcing a court judgment, which is the biggest reason why you would want to have an arbitration agreement, because people, again, will more likely perform if they think they'll be held accountable. So people will not pay if they think you'll be able to enforce your contract, versus maybe they will be in a place where you won't be able to enforce it. So why should a business favor arbitration? Just a quick little graphic for, why would, from anyone's perspective, you would want to have arbitration versus court. And I'll explain these all very quickly. But you will see that there are far more reasons to consider having international arbitration in any business contract that's international than not having one. And the default of not having one is you go end up being in court if anyone has a dispute. And again, you don't want a dispute. You want people to avoid disputes because they will think there'd be no advantage of going to court because somebody is in a different country than the other party. So first thing, and I've touched on this already, business interest of having an enforceable judgment. So what's important takeaways is right now, if you have nothing in your agreement about arbitration, by default, parties will have to go to a court. And the agreement hopefully should address where there would be a court proceeding. Often in international disputes, that's a point of negotiation because everyone doesn't want to be hometown. So often you may pick a neutral site, or I've seen agreements where if there's going to be court proceedings, you file it in the other person's home country. But the reasons why you want to consider arbitration versus court is there's no international treaty that requires a foreign court to give effect to any U.S. court judgment. And let me stress that again. There's no treaties with any other countries for anyone in the United States where if you get a U.S. court judgment in a dispute, they have to in any way recognize it other than under the laws of the foreign country. So just to make sure everyone understands how important this is. So let's assume you don't have an arbitration agreement and somebody doesn't pay you and you bring a lawsuit against them in the US, you get a judgment against them. They don't have any assets in the United States, which is common in international. The parties have assets in their own countries. And so you get your judgment against them, whether it's contested or not, from a fine court in the US. And now you want to go take your judgment for, I'm just going to pick an arbitrary number, $5 million. You want to go to wherever they may be, and whether it's Cameroon, it's in Brazil, it's in France, it's in Canada, it doesn't matter. You have to go to a foreign court. You have to file a proceeding in the foreign court, which may be more involved depending upon which court. And then without a treaty or any way to predict, you need to hope that the other country will recognize the U.S. judgment and turn it into a judgment in their home country, and then allow you to enforce it against the party's assets in that country. A lot of steps, a lot of unpredictability, and frankly, it's the wild, wild west. It's one of my practice areas. I do this all the time, and it's extremely unpredictable. A couple illustrations. I've had disputes where the other party's big companies' assets are in Germany. You would think that would be a place that would likely recognize a U.S. court judgment. When I do this type of disputes, I'll bring in somebody to help guide me from Germany, for example, where I have a lot of lawyer relationships in almost every part of the country. They'll help me to make sure I do everything I can to get the U.S. judgment to be one that should be acceptable to a German court where the party's assets may be. You get the judgment, you go to Germany, and you may or may not get it enforced. I've had mixed results. Right now, I have an interesting proceeding where I'm trying to enforce a U.S. federal court for many millions of dollars in China. We in the United States recognize Chinese court judgments. The number of judgments recognized from the United States and China right now is extremely small. And when I say extremely small, meaning the ones known are well under 10. And so interesting proceeding going on as we talk. If the lawyers in China I have working with me, if they can pull this off, they'll be, very well known because it'll be that big a deal. And if you have a jury verdict, since a lot of the world doesn't have juries, common law countries like the United Kingdom, those countries, United Kingdom, Canada, Japan's starting to have some juries, but most of the world is civil law. And again, why you need to have somebody assist you with all these little issues, because civil law, common law, civil law is very statutory. It's not the way the US does things. But they don't really typically recognize US jury verdicts as well as they would a judge verdict because they just don't have them. And then what I'm going to touch on is what makes everything different for international arbitration is, you'll see as the highlighted bottom bullet here, the New York Convention is a convention from the 1950s, which requires enforcement of foreign arbitral awards. What that means is if you go to an arbitration, instead of a judgment, you'll get an award. And unlike judgments where there's no treaty, no agreements for anyone to recognize a US judgment, the New York Convention, as you'll see in a moment, is basically covers the entire world that anyone on this call or anyone will ever do business. The only countries that are not part of the New York Convention, which goes back to the 1950s, which has an agreed upon protocol for recognizing and enforcing a foreign arbitration award, are countries like Iran, Chad, places, North Korea, places you're highly unlikely to be doing business. So when you need to collect on a judgment, this is why you should be considering arbitration. Here is a great visual that will hopefully reinforce a business interest in what happens if you have a US judgment. If you notice that the whole map is blue except for the part that's red, that's the United States and Alaska. And the reason why the rest of the world is all a different color is because there are no agreements with anywhere else in the world to recognize a US court judgment. So again, it's the wild, wild west. Law will be different in each country. You may be hometowned by courts, no treaties, no international reciprocity required. And even if you have a judgment in another country and want to enforce in the US, again, it's the US law that applies. There's no agreement. It's not the same anywhere. Even in the United States, it's different by each state to some extent. So it's sort of like the wild, wild west, which is why, from a business interest, you want to have the ability to enforce your agreement. On the other hand, if you have an enforceable award, which is what comes out of an international arbitration, you'll see by this map how broad the membership of countries are who have signed on to the New York Convention, the treaty that I mentioned since the 1950s. And you'll notice that there's very little places in the world, probably nobody will be doing business on this call or any of your colleagues in these parts of the world that have not been already members of this treaty. And again, what that means is by treaty, everyone has agreed to follow the same protocols in recognizing and enforcing an arbitration award if you ever had to go enforce your international contract. So this is the difference. We have nobody to virtually everybody. So that alone is why, frankly, international arbitration is such a powerful tool and why it's so important to be aware of it in the event that you have a contract where you want somebody to pay or perform and you want to have a real remedy. And it doesn't have to be just money. It could be things such as agreements not to use your website. And then, okay, what do I do if they're a franchise or a licensee and they're now using my property, my intellectual property rights or my website or something I gave them rights to? If you have to get a court judgment, it's a long unknown proceeding. If you have an international arbitration, it's pretty likely it'll be enforced if it's done properly. And again, you don't want to dispute. You want to be having people perform because they know they'll be held accountable. So a little bit about enforcement of arbitration awards, and don't want to get too legal, but just enough for everyone to have some basic understanding to spot the issues and to know enough as a business person as to when you should be thinking about these things when you do your next international agreement. So once you have an arbitration award under the New York Convention, the treaty, it's not recognized per se. However, you need to get it recognized by where enforcement is sought. So, for example, and I do this as part of my practice all the time, about, probably 40 days ago, I believe I had the first one in the United States. So in China, there's now over 200 different arbitration tribunals that are active, and they claim, and I have no reason to doubt it, that they have over $1 trillion in monetary disputes in these different arbitration centers. And so you'll find if you do business in China that there's a Beijing International Arbitration Commission. There's one similar in Shanghai, Shenzhen, virtually everywhere you could think of. And they're all extremely large and they're all very active. And again, why? Because in China, there's a big benefit of having arbitration. And China's been a member of this treaty, the New York Convention, for a very long time also. So I just recently had a arbitration in the Shenzhen Court of International Arbitration, Shenzhen Court of International Arbitration, commonly known as the SCIA. You'll find in the international arbitration world, everything has letters. Not sure why, but it's just the way it is. So there was a very large award. My involvement was, while it was all in Chinese, which I'm not fluent in, but I'm very aware and have expertise in how to deal with different languages when you have those types of issues come up. That's a whole separate conversation we could have separate from just international arbitration. But Ward entered in the Shenzhen Court of International Arbitration for a large amount of money. The parties who have lost are in the United States, in California, actually. And so now it was a question of having the award and my getting it recognized and enforced by a U.S. court so that the award can then be enforced as a U.S. judgment under the New York Convention, the treaty. So had this not been by arbitration or by court, I've done these too, I would have had to, just to give everyone an idea of why arbitration is such an important thing to be aware of, I would have had to file a brand new lawsuit in California seeking recognition of a Chinese court judgment. I would have to serve the complaint like any other complaint, and it could take a year to 2 years to get the judgment recognized in California, turned into a California judgment, so it could be enforced against the parties. And that's sort of the typical way you would do this if you don't have an arbitration agreement. On the other hand, they had this case I'm mentioning as an example, had an arbitration agreement. So they had the arbitration. Once that occurred, one side won, they have a award, they want to enforce it in the United States. So here's how that's different, because there's a treaty. I then filed a petition rather than a lawsuit to enforce the arbitration award in China. Unlike the judgment scenario where it's another court case, the petition is like a motion, and I was able to, once I served my petition on the other side, have it heard in less than 60 days and a resulting grant of my petition to recognize the arbitration award under the treaty and turned it into a judgment. So to my knowledge, I'm the first person in the United States who has taken a Shenzhen Court of International Arbitration. It's where they do a lot of technology in China, and get one of their awards recognized and enforced in the United States. And in fact, I probably will have a call on Friday as to our next step. This is all very recent as to what do we do now, but we now have a United States court judgment. And I'm illustrating for everyone to just sort of see how different the arbitration is versus the default of you go to court. And if you don't say anything, you go to court. Because arbitration agreements have to be in writing and entered into by the parties. So a couple, this is just in the slides. I'm not going to spend much time on this, but under the treaty, there are some bases that you need somebody experienced to help you with as to when an arbitration award will not be recognized around the world. And basically the typical ones that are worth noting is if the arbitration was contrary to the parties' contract, sort of obvious things, or where there's a failure in the arbitration to do what was agreed to by the parties. And the importance of arbitration agreements is you can customize everything. So unlike in court, where there's no customization, you just follow the court rules, you can decide ahead of time what law will be the law that governs, what language the proceedings will be. You can decide the scope of what information will be exchanged. And I'm going to get into this a little bit more as to other big benefits for your business of international arbitration over court. If it's a contract that involves information that is highly trade secret, confidential, proprietary, you probably don't want to have it in a court where you have to worry about everything being open. International arbitrations are typically confidential and private. There's lots of different things you can do to customize an arbitration agreement. And while this is not today's topic, if the takeaway from all today is that your next international contract should include an arbitration agreement, you do want to have somebody not just cut and paste something and just assume it works. You want to have somebody for the actual transaction help you make sure you're doing the things that make sense so that, again, your agreement will actually be performed and there will not be a dispute because you have a well thought out dispute resolution provision. So, if an arbitration award was obtained by fraud, meaning, for example, you could, very rare, but if you could prove that an arbitrator was paid money or something, you would have a basis for a court not to recognize your arbitration award. And the one that's probably worth noting is where recognition or enforcement would be manifestly incompatible with the public policy of the requested states. Typically hard to do, but it's something you want to be generally aware of as to, for example, most international arbitrations that I'm aware of, there's no such thing really as punitive damages typically being awarded, even if you pick a law where punitive damages exist, just because in a lot of the world, they don't recognize punitive damages, just as an example. Some other grounds would be are here. I don't want to spend too much time because it's a little more legal focused, but I didn't want to just skirt the whole, general understanding of what you should be aware of. So, there's an exception to the treaty if there's judgments already between the parties. A lot of technical things, but as you're going to take away from this is there are not that many grounds for when recognition or enforcement of an arbitration award may be refused of the New York Convention. It's very limited. So the default situation typically is if you had a proper arbitration, people had due process, meaning they were aware of the proceeding, they had an opportunity to participate, or they did participate, there's no fraud in the proceeding, highly likely it's going to be recognized around the world because there's a treaty. So just to go back to some of the things I touched on and just add a little more depth. So business interest in international arbitration. First of all, unlike a court, again, the default, you're going to get a judge appointed or selected, and typically you don't know who that judge may be. Judge may or may not have experience in the subject matter of your case, of your dispute. Let's assume that you have a dispute over the international sale of goods, and another topic, which I'm happy to talk about some other time. There's the Convention on the International Sale of Goods, the CISG, which is the law of most countries except for like England. So instead of like in the United States, where we have our own uniform commercial code over how sale of goods are handled, there's an international treaty for a long time that most parts of the world are part of. You may want to have people who are familiar with that. Most U.S. judges probably never heard of it. Most U.S. lawyers never heard of it. I see all the time cases where the CISG applies because it applies by silence, meaning if the parties don't opt out of the CISG, the Convention on International Sale of Goods. It controls, and in the United States, under the Constitution Supremacy Clause, an international treaty is the law of the land. So California law is, if you have a sale of goods between two countries or more that are party of the Convention on the International Sale of Goods, that law applies. Most people are clueless. Most judges aren't. You can, in your agreement, define what type of arbitrators you want who have experience in the nature of the contract. So, for example, you could spell out you want people familiar with the Convention on the International Sale of Goods. If it's a dispute over agricultural sales or technology, you can actually pick where your arbitration will be done. And you can even specify you want people with some background in the areas that are very technical, which a judge would never have. And in the United States, you have juries. Do you really want a jury to deal with a very complicated technology when you could, by agreement, have experts in the field be the ones who hear your case, have familiarity with the subject matter, and decide a dispute for everyone? So this slide sort of illustrates, the litigation, which is the default of court. You're arguing your case, which is maybe very technical, to a jury who may or may not have any idea as to any of the subject matter or sophisticated issues of your dispute. And if you have a arbitration, you can pick who is going to be the type of persons who would qualify to be arbitrators and pick people who are very sophisticated. And then also, even if you don't do that, you still will have an ability to be involved with who are the arbitrators selected for your dispute. So do you want to have no control or a lot of control if you ever had a dispute take place? Another reason why, for a business interest, arbitration has many, many advantages over again, the silence of just being in a court someplace in the world. I touched on this earlier, confidentiality. If an agreement involves confidential information about your company or the type of technology or goods at issue, if you're in court, you don't have a lot of ability to keep your business secrets easily secret. It's very complicated to not have things in a court record public, even just the nature of the fact that you even had a dispute. On the other hand, in an arbitration, your business secrets are going to be kept confidential. The proceedings, the fact that you even have the arbitration, will be much more confidential. In the United States, as people may know, if you have a lawsuit filed against you or by you, it's a public record, and everything that's filed in the case is generally a public record. So if preserving confidentiality of the dispute or the nature of the contracts between the parties and so on are something you want to keep confidential, consider arbitration. Huge difference for businesses and very important to be aware of. Just a quick little caveat. While confidentiality protections are not perfect, even in arbitration, you still have to be careful. And again, you need to have people who are very sophisticated and experienced in the area to help you. But the confidentiality and ability to keep things private are so far greater. And it's why big companies often will be who are sophisticated will have international arbitration agreements, because they just don't want to have all of their business, the contracts they have, a public record around the world. Another big business interest. So one of the reasons that I do a lot of international work and transactions where I help make them work around the world is people's correct perception of how our court processes work here. I think everyone here, doesn't matter if you're been involved with disputes or not, are generally aware that in the United States, we have a extensive discovery, meaning basically as a rule, you can obtain all information from the other side as long as it's admissible in court, somehow relevant to the subject matter, or reasonably calculated to lead to the discovery of admissible evidence. extremely broad type of discovery. We have depositions, we have extensive requests for documents, we have extensive interrogatories, questions where people have to answer under oath. It makes people afraid to do business in the United States because in the rest of the world, they do not have the type of discovery we have in the United States, which is extremely invasive. And I will assure you that it pauses many big companies from wanting to do business because of the fact of how expensive and how invasive this type of standard U.S. discovery is if you're in court. And that's why it's important to keep discovery limited or minimal for many businesses. And if that's your goal, you want to have international arbitration. On the other hand, here's how international arbitration works. And it's international in the sense that the concept of U.S. style discovery really does not exist. I can't stress that amount different. So, for example, in the United States, it's standard for everyone to take depositions, testimony under oath, and they may do it around the world. Creates huge expense, a lot of time. Plus, you get to ask for all types of extensive, every possible stone unturned to find evidence, good or bad, from the other side. In international arbitration, you rarely have depositions. The rest of the world doesn't even have depositions, by the way. So this, again, very international. You do have this limited document disclosure. And you typically don't have witnesses testifying in an arbitration. You get written statements and then the ability to cross-examine at a hearing. So for the rest of the world, that's what they're generally would be used to. And it's very international, non-US, which again, if you're doing international business, the rest of the world doesn't want to do business with you if you happen to be in the United States, in large part because of the fact that they're afraid of what happens if they ever get a dispute and how much it'll cost them and how invasive it'll be to, spending time management. And I can go on and on as to why US style discovery is so unique. So if you want to have the discovery limited for costs or minimal, including just to make disputes affordable, relatively, another reason to consider international arbitration. And this is just a slide. You could ignore the numbers. It just happens to be in a case that would have been a very expensive case. But, well, you never can know, but arbitration should be cheaper. And unlike in the US, where you have to have in your agreement that the losing party pays, it's sort of the default international arbitration, including in California, which is, again, very non-US. And so same type of expensive dispute, but to give an idea, on the left, you have a typical amount of money and time spent on a court case, huge amount of time, very expensive discovery. That's the depositions, endless requests for documents. You have a motion practice, people going to court, and then you have a long trial, and then you may have an appeal, which adds to everything. In arbitration, typically, you do have some money to pay for the arbitrators because they're paid for by the parties. You have comparatively very small amount of discovery because you're really just exchanging documents with some limited requests to get documents from the other side. A lot more time spent on briefing because you're submitting to the arbitrators your evidence in writing. And then a much more short hearing, which is typically arguments and cross-examination of witnesses and expert witnesses. And so the difference is huge. And again, ignore the numbers. You could just use this more as a comparison as to a typical involved court proceeding of the same type of dispute versus an arbitration proceeding of the same dispute. Speed and finality, another business interest that may be the case. Again, if you don't want to pay, maybe you don't want to have things be speedy or final quickly. So in an arbitration, just how it works, if you make a demand for arbitration, there's a dispute and the parties don't settle, you get your arbitration tribunal constituted. Typically, you pick in your agreement who's going to govern the arbitration, so you have rules that everyone follows. You don't need that, but it's usually a preferred thing. And once you get the arbitrators constituted, you go to a merits hearing, which is like a trial, and you get a final arbitration award. There's no appeal process. There are ways to challenge the arbitration award under the New York Convention, the treaty, but that's it. Very quick, very final, unlike court, which will be much more likely time consuming, may go on for years, longer, and also has the potential of appeals. So on the other hand, as I mentioned, litigation, you file your lawsuit, and then very long time periods when you may get a verdict, and then there may be an appeal, so nothing is really final. So if speed and finality are important to your business, you want to consider international arbitration. Let's assume that you can foresee the need for some type of injunctive relief while your dispute is proceeding. And this would be typically, let's say somebody is using your technology or trade secrets, and you want to get an order to maintain the status quo, so prevent them from using your trade secrets while the proceeding is goes to a hearing on whether or not they have the right to do so. I'm just coming up with one of endless examples. In litigation, trial, you go to court, you have to go then file a complaint and the lengthy time period potentially to get to a verdict. And on the other hand, if you have an emergency need for injunctive relief, if you have a proper arbitration agreement, you get your emergency arbitrator, you may do an application for emergency measures, and that all takes place very quick. Not a lot of appeals of any kind, and then you get to your final arbitration award. And it could be more than just injunctive relief. Let's assume that you want to free somebody's assets, or rid of attachment, we would call it in the US. You can do that, and if you want to have a well thought out arbitration agreement, but much more advantages of your controlling the process. And then last thing I want to do before we get if anyone has any questions, just a very quick preview of California International Arbitration Week. So there's a link here. Feel free to click on it, and you can look at it later. It's a link to the website for California International Arbitration Week, which Global Chamber is a sponsor. And I just want to quickly sort of highlight why you should consider attending, whether you're a lawyer or not a lawyer. There'll be something there for everybody. And for a business person, huge awareness opportunities of learning about how international disputes work, so you could be better at spotting issues. In addition, we're going to have, you'll see 24 panels, over 115 speakers, many from around the world. We'll have people coming from all over the world. In addition, let me just click on the link and I will get the website up for everyone. So if we look at the schedule, you're going to see that the types of programs we have are incredible. So if you happen to be a lawyer, and I don't know if we have any lawyers on the call, it's an opportunity to get a lot of legal education and specialization credit. But we're also going to have 4 nights of totally free, incredible offsite hosted networking events. So as an example, just a typical day. So we'll have an early arrival dinner Sunday. That's only self-pay. Everything else is included in a very low-cost registration. We'll have all these programs. And so, for example, if we look at the one at 10:15 on the first Monday, we have one reaching across the wall, navigating U.S.-Mexico disputes in a changing legal landscape. And we have incredible speakers from not only the U.S., but from Mexico. So, I could go on and on, as you're going to see real quick, but huge opportunities for interesting things. Here's another one on nearshoring opportunities and its impact on international arbitration, things to be aware of.
I'm sorry, the screen didn't change, so we can't actually see which.
Oh, I'm sorry. Let me bear with me a minute. We do another share.
Thank you, Demetrius.
Yeah, sorry about that. I just assumed when I clicked on the link, it opened up on my end, it opened up for everyone else. So let me. Okay, now everyone's seeing my screen. That you now see the schedule for International Arbitration Week?
Yes,
okay.
we can. Thank you.
Thank you for saying something. I'm assuming it automatically shared. So live and learn how that works when you open up a link. So when I was just on Monday, I'm just giving examples. So here's the, 2 dealing with Mexico issues with incredible speakers from around the world. And then, by the way, it's a hosted lunch. My firm's one of the hosts, which will be at, you go through Tulsa, which we've had a Global Chamber event at in Westwood. The event's at the W Hotel in West Los Angeles, so great venue. Everything will be at the one hotel for the 4 days. And so, like, for example, again, from the Beijing Arbitration Commission, so this is all just Monday, IP protection in the age of AI and big data, insights from China and the US. I mean, these are all topics that should be of interest to everybody. And so you'll see, again, we have incredible speakers. And again, they're speakers from around the world. And then we have on Monday, insights on global IP cases. Again, this one's from Singapore, focusing on issues with US, Singapore, and others. And it's going to be incredible. I know many of the speakers, and these are people you would never be able to see speak. And then we're going to have a hosted networking reception. And again, all free once you register. Tuesday, we'll have one on sports arbitration. So it basically things about not only just the Olympics, but including speakers from around the world on, how do you deal with sports disputes and sports agreements. And I'm just going to try to clear. So another great one on artificial intelligence from Silicon Valley with great speakers. Some of these speakers, these are from all over the place, by the way. Here's a great one put on by the Hong Kong International Arbitration Center on the 2 Bay Areas, our Bay Area and the Greater Bay Area, in exchange and high-tech arbitration, but basically exploring issues of exchanging information. And while this isn't a legal framework, I will assure you that the substance would make sense for anybody who's involved with cryptocurrency, AI in your practice, and so on. And then, for example, on Tuesday night, we'll be busing everyone, again, this is all free, to Sony Studios for an old Hollywood night. And so we'll have all types of, this is just an example of every night, but the importance of this is what a great opportunity to network with people from around the world, and all again at an incredibly low cost. And then on Wednesday, we'll have, here's a fun one from Spain, the Madrid International Arbitration Center on technology and culture and international arbitration. But these are just basically issues everyone, business person or lawyer, should be aware of, dealing with various legal cultures and advanced technology. Again, speakers that are stellar, very diverse, by the way, around the world. And then we're going to have on a great program on India and India's role in the future, dealing with issues of M&A, healthcare, and energy. And then we're going to have, again, great speakers, including from India, resolving disputes, construction, and energy across Asia and Latin America. I'm just giving a quick little flavor here. Another networking reception on Wednesday night that'll be really great. That's going to be at the Broxton Brewery in Westwood. Again, all hosted. Then the last day, we're going to have some really great programs. Here's one that I'll be speaking on, actually, looking at how courts in California measure up against those of other leading seats, where the seat is where you hold the arbitration hearing. And we're going to be looking at China, the US, and New York, and all Paris, and all over the place. And then we'll have a great program on women in arbitration. And another great program on a greener future, experiences from the East and West. And we'll have a fun one and a debate using the use of AI, artificial intelligence, determining damage awards, is sort of like maybe what the future will be. And then we'll have our last night, which will be a networking reception. And that'll have fun. I'll have a pop quiz. Again, lots of fun things. And if you want to see the pricing, I've been mentioning that. And again, this is all in the link, so easy to find. For those of us who are probably everyone in the audience, it's there wasn't early registration, $375 for 4 days, 4 nights of hosted networking events. So wonderful opportunity for people to meet with people from around the world, learn a lot, and I would encourage everyone who does international business to consider attending. It's not just for lawyers. And so that's the end of what I wanted to cover. I know it's 8:53 and I'm happy to take any questions. I covered a lot of material pretty quick.
Sounds good. Does anybody have a question? I don't see a hand raised, but does anybody would like to unmute or
I do.
jump in?
Hi, it's Anita.
Hey, Anita.
Hello. Not turning on the camera, but so I have a question. To become part of the New York Convention, is it a similar process to that of any US treaty with another country or group of countries? And along those lines, is withdrawal from that something that is easy enough to do that a president can just say, well, we're leaving this treaty? The reason I'm asking, obviously, is because it seems to be too easy for countries just to say, oh, we're not going to honor the treaty anymore, the US being a prime example. And how does that affect the treaty and the respect for the treaty with everybody?
By the way, Anita, great question. And let me answer it as follows. So first of all, the treaty's been around since the mid-1950s. There's 172 countries who are now members. That's why when you saw that map, it's virtually everywhere in the world that you would ever possibly do business. I don't think anyone in Global Chamber probably would ever do business in the countries that are not covered. Russia, for example, and I'll touch on that in a moment, is one of the longtime members. And so it's pretty inclusive. Second, it's a treaty like any other, so each country has their own protocols for treaties. In the United States, it requires approval by the U.S. Senate. Second, because it's basically a core international business, including the biggest corporations. So, for example, if you go through the speakers on the International Arbitration Week, you'll see we'll have like a general counsel from Chevron because they use international arbitration on everything because of the obvious reasons I've spelled out for why you would want to do that if you're sophisticated at all. So I doubt if in the United States there would ever be any appetite not to have international arbitration continue under treaty just because it's so institutionalized in the biggest of companies in the United States. It's the smaller companies that are less aware of these types of issues because they don't have experienced people who even know of the issues, or they're business people who just aren't being able to issue spot, that probably are the ones that don't have international arbitration. To pull out of the treaty would require each country separately. I just don't believe that. I don't think you could have Trump say, I'm not going to follow the treaty, but since it involves private businesses voluntarily agreeing to it, I'm not sure if he could even on his own unilaterally change anything. I'm just not sure how that would even possibly work. The type of treaty that don't get followed are ones that are really controlling a government, meaning a treaty where the governments agree to do things. This is all individual private companies voluntarily agreeing to have their disputes determined by international arbitration. And so touching on Russia, for the moment, Russia is somewhat a pariah in the international business world. There's obviously a lot of sanctions. They are a member of the treaty. They're still recognizing and enforcing the treaty. There are some, without getting too weedy about it, there are some issues that have come up as to whether or not they're following their treaty obligations in the last year or so, as well as they could be or not. But even there, the treaty still is in place. And again, a reason why you'd want to have somebody in your team who would have access to Russian lawyers. I know some Russian lawyers who aren't in Russia, but they have practice in the UK and the US. But generally, that should not be a concern for all the reasons I mentioned. But it's a good question. And I will add that just in the last couple of years, there's been a number of additional new countries to the New York Convention. So it's growing. I'm not aware of anyone ever pulling out. Pretty sure that's not happened. But just since I started speaking on international arbitration, which I've been doing for about 15 years now, I believe probably like 10, 12 new countries have joined the New York Convention. So that's the trend.
Well,
Awesome. Thanks so
Anita,
much.
did that answer your question, Anita?
It did. Yes. Thank you.
Hey, Jeff, we're at the top of the hour. Any final comments that you'd like to make?
Feel free, anyone who ever wants to talk or have a good international arbitration provision in a contract. That's something I do frequently, even when I'm not doing the contract. I just get brought in for helping with how to make it work internationally, since no offense to my other lawyers in the United States, but a lot of people don't have that type of background or specialty. And then happy to be of assistance to anybody on anything. It doesn't have to be international. And if anyone has any follow-up questions, feel free to reach out to me. And again, Global Chamber is a sponsor of California International Arbitration Week because it's so important to everybody's international business. And just to give everyone an idea of how international this is, one of the things that I founded this annual program and have been a co-chair for all 4 years, including this year. I'm the only one who's continued as the only co. We have 2 co-chairs, but as the continual co-chair. I just want to show you the non-monetary sponsors. And non-monetary sponsors are promoting the program around the world. So that's one of the reasons why we have people coming from all over the world. And it's really it's probably the biggest international event of this kind in all of California each year now. So if you're interested in meeting people, by all means. I'm just going to scroll down real fast just to give everyone a little quick idea of the breadth of the organizations around the world that are promoting California International Arbitration Week and why we do have such a big international audience. I had somebody contact me from Nepal a couple of days ago wanting visa letters, invitations so they could come. And how they found out about the event, I have no idea, but it just grows and grows every year, which is so exciting. And the whole reason we're doing this, by the way, the International Arbitration Week, is to raise awareness of international arbitration. California, we're one of the biggest global economies in the world. We're the 5th largest. At the same time, most people in California are not that familiar with how international business really works and opportunities. So you'll see we have the California Chamber, we have German, we have all types of different groups. Interap is Japanese chapter primarily. Here's Global Chamber, Global LA, the Hainan International Arbitration Court, and I'm just going to quickly scroll down, but you'll get a quick breadth of how many organizations around the world are involved with what we're doing. Here's Korea, the LA Port, the Mexico Consulate in Los Angeles. Here's the Nepal International ADR Center. We just added them. Philippines Dispute Resolution Center, because this is a global topic. Shanghai, Singapore, Shenzhen, another Shanghai, Silicon Valley, Tel Aviv, Jimin Court, Vancouver. And by the way, as a relatively new arbitrator, I'm an arbitrator on the Vancouver International Arbitration Center panel, the Japan Commercial Arbitration Center panel, and the biggest one connected to the United States, the International Center for Dispute Resolution, which is the part of the American Arbitration Association. And that's how I said it's currently am getting cases as an international arbitrator in addition to domestic ones. So hopefully that gives everyone an idea as to like why you should come to Los Angeles, March 10 to March 13, and be part of this amazing international event.
Amazing information. And from my own experience, people, when they do events in LA, they do them right and they do them really well. And Jeff is not only well connected, but he knows what good events are. And so I'm going to guess this could be one of the most interesting, fascinating, entertaining, informative, and important events that you could attend to. So if there are people that that could be interested in this for their business, please reach out to them and we plan to do the same. Thanks, Jeff, for all that you do. Thanks for sharing the information and, of course, about the conference.
My pleasure. And feel free to reach out to me if anyone has any other questions or need for having a good international arbitration clause in your next contract.
If you're watching this video prior to March 2025. Please reach out and find out more information about the conference, and otherwise, always learn more from Jeff on arbitration, international arbitration, and the law. Thanks, everybody. Have a great rest of your day. Thanks, Anita, for your question. Really good one.
My pleasure.
And Demetrius, thanks for helping out as well. What do you think of this, Demetrius? Is this an area of interest?
This was so fabulous. I've done international arbitration, but Jeff, like, he lays it out like so beautifully that I mean, it's almost like I feel like my 12-year-old could have understood everything that happens. But in this conference, I can't wait. I'm getting off of here, registering, and getting my ticket.
Love it.
Fantastic. So I get to see you again. That's cool.
Yes.
Awesome.
Thank
Awesome.
you.
And where are you based?
I'm Chicago based, so
Okay.
we have a lot of litigation. We need to
And
be.
by the way, I just had a request for, I did a visa invitation letter for 3 lawyers from Cameroon. You know, I can't tell you for sure they're coming, but this is a interesting event attracting people from around the world. And for lawyers, there's 24 hours of, I'm sure California and Illinois are reciprocal, I believe. So, you know, where do you get 24 hours of legal education for that price? Plus the evening events, nowhere. So that's the
I've
lawyer
done it.
part, but there's stuff here for everybody. I try to always tell people, I have a lot of business friends, and you know, this is really an opportunity to really learn a lot and have fun also. The evenings will be a lot of fun.
I'm so excited. Thank you so much.
Thanks, everybody. Thanks,
Welcome.
Jim.
Thank you, everyone.
I think that's it. Take care.